Hi everyone, I'm Taylor Hudak. I'm in London covering the first part of Julian Assange's full extradition hearing. Now this first part of the hearing did conclude on Thursday, but just to kind of summarize what took place this week, I am joined by the editor-in-chief of the Duran and former attorney, Alex Mercouris. Alex, how are you doing?
I'm delighted to be here and talking about this complicated case with you, and I'm very happy.
So just generally speaking, what are some of the main points that we can take away from this past week?
Right, I think the first thing to say, and I think this is an important point, is that the Crown, the representative of the government, the lawyer who's representing the government, has admitted that these are political charges which have been brought against Julian Assange by the government of the United States. I didn't think that they would do that so readily. I thought they would try and argue that they are pure criminal offences, but they have admitted and accepted that these are political offences. So that's an important admission, and I think a lot of the discussion hasn't quite got to the fact that that is an important admission in itself. Now, why is it important? Because the tradition in Britain, going all the way back to the 19th century, to the mid-19th century, is that Britain doesn't extradite people who are charged in other countries, by other countries, with political offences. They've always been willing to extradite people who are charged with crimes, with pure crimes, but there's always been a certain unwillingness, an unwillingness to extradite people who are charged with political offences. And this is something which is not only the British tradition, but which historically the British were very proud of. So that was why you had all these people who had committed political offences in their countries, people like Karl Marx and Lenin and the people who fled from Eastern Europe and from the Nazis, and all these people, they came to Britain because they felt secure and comfortable here, because though they were charged or potentially charged with all kinds of things in their respective countries, they knew that the British would not extradite them. So the British have admitted these are political offences, and yet Julian Assange still faces an extradition case which has been brought against him.
Why do you think they are treating this case differently?
There is only one reason why they're treating it differently, and that is because, of course, the country that is applying for the extradition is the United States. Britain is an ally of the United States, a very close ally. It's very economically and politically dependent on the United States. The present government is also very connected to the United States. And of course, the other thing which is a part of that explanation is that the person involved is Julian Assange. Julian Assange has embarrassed the United States, and that means that he's also embarrassed the British government. So they're looking now for ways to extradite him to the United States, despite the fact that they've admitted that he has been charged with with political offences. So this is why we have this very complicated and intricate argument going on in the court now on the difference between the Extradition Act of 2003 and the Extradition Treaty of 2007.
Yes, can you explain in a greater depth the difference between the US-UK Extradition Treaty and the UK Extradition Act?
Right, the thing to say is that Britain has a very complex approach to international treaties. This stems from the fact that the British historically have always considered their parliament, to be supreme in making law. But it's always been understood in Britain, and it's always been a legal principle, that the body that makes treaties with other countries is the government, exercising this archaic principle. You have a very archaic constitution, this archaic principle of the royal prerogative. So the important thing to understand about the royal prerogative is that it can make law, and it can bind Britain to certain treaties and to certain commitments which Parliament itself has not itself committed itself to. So we have this tension which comes from within our very archaic and old-fashioned constitution. Now, what usually happens in Britain is that you have an act which is passed by Parliament. In this case, it's the 2003 Extradition Act, which gives power to the government under the royal prerogative to make treaties, and it has gone and used that power to make the treaty with the United States, which is the 2007 Extradition Treaty. So it is the 2003 Act which has empowered the government to make the treaty with the United States, which is the 2007 treaty. Now, that sounds more complicated than it perhaps is. The important question is, which of these two takes precedence? In fact, neither does. The one has to be understood with respect to the other, because the 2007 Extradition Treaty could not exist were there not a 2003 Extradition Act. But that doesn't mean that everything that is set out in the Extradition Act is binding and that the principles in the treaty are not. Is that clear? Because this is so, it can sound more confusing than it is. To lawyers, it's not confusing at all.
Can the defense still therefore argue that in fact Julian Assange is being extradited, or the U.S. is wanting to extradite him to the U.S. for political purposes? Is that still a fair argument?
Yes, I think it's in fact the central argument, because I was expecting that the Crown was going to resist the claim that they were political offences, because it's so contrary to British tradition to extradite people for political offences. What they have done, and I think that it's legally questionable to say the least, is that they're arguing that because the 2003 Extradition Act doesn't refer to political offences, that means that he can be extradited for political offences, even though the 2007 Extradition Treaty says that he can't. So the argument that the Crown is making in court is that the court can go beyond what the British government bound itself and Britain to do in a treaty which it made with the United States. I think that is a desperate argument. I think it's extremely bad law and very dangerous law, because though the 2003 Extradition Act doesn't refer to political offences, I don't think, and I'm sure most lawyers would agree with me, that that means that Britain is entitled to extradite people for political offences. It seems to me that if you do that, you are disregarding a huge body of law which has already existed in Britain, as I said, for over 100 years, which says that you don't do that. And of course, given that the treaty is what the United States is relying on to bring this extradition claim, and that specifically says he can't be extradited for political offences, I think that to argue that he can be extradited for political offences simply because the Act is silent about this is actually absurd. Legally, it is absurd. It sounds complicated. Again, to a lawyer, it is not. And the only reason it is complicated, it appears complicated, is because it is such a bad argument. When in law, arguments are complicated, that is always a sign that they are weak arguments. And that's an essential point to understand.
That's a really good interpretation and a really interesting perspective as well. I wanted to touch on also some of the controversial aspects surrounding what is taking place inside the courtroom. Mm-hmm. I know Assange has been not really been able to participate in the hearings. He's been sitting alone in a glass box. However, his attorneys did file a request for him to be seated with them. Can you kind of clarify what's been going on in the courtroom?
Right, well, I think the first thing to say is that there is a body of law from the European Court of Human Rights, and it's important to say the European Court of Human Rights administers the European Convention of Human Rights, which is part of British law. The British have actually taken that convention and have made it a part of British law. That body of law, which the European Court of Human Rights has developed, says very clearly that the layout of a courtroom is relevant to whether a trial is fair or not. And a fair trial is a human right. That's an important point. That's the starting point. Now, as part of that discussion that the European Court of Human Rights has made about layout of courtrooms, it's actually considered docks, the kind of places where prisoners are kept. And there is a very substantial body of law which says that putting prisoners in cages, in boxes, armoured boxes, is or can be contrary to the principle of a fair trial. It can actually mean that the hearing is no longer fair. And the extraordinary thing about this is that the judge in this case seems to be ignoring all that very extensive body of law which exists. There's a few points to understand about this case. Firstly, Julian Assange is a peaceful man. He's committed no violent crime. He is not a danger to any member of the public, and the Crown itself accepted in its discussions with the judge that it's perfectly appropriate. It has no objection to Julian Assange sitting in the body of the court with his lawyers. Yet the judge, remarkably, has been harsher on Julian Assange than the Crown has been, and is disregarding this body of law from the European Court of Human Rights by insisting that he remains closely confined in this sealed dock where he is not able to communicate properly with his lawyers. To my mind, again, that calls very much into question, firstly, whether the trial is fair, and also, which is of course a further point about the trial is fair, the impartiality of the judge.
Exactly, and I think that historically in this case, it's been said before that the judge has been showing a favoritism towards the prosecution, which is very concerning, because I believe that if this was a fair hearing, considering the facts are on the side of the defense very clearly in this case, there would be a much more positive outcome here. Now, looking ahead, what can we expect in May? I know that the hearing will resume May 18th and should last about 3 weeks. What is going to take place during those 3 weeks, and what predictions do you have?
Right, the first thing to say about this, and just to touch on the judge, firstly, I don't think there was any reason at all to insist that Julian Assange be kept in that box. He should have been allowed to sit with his lawyers in the courtroom. Even the Crown was prepared to agree. That's a very bad sign. The second point to make about the judge is that we've been having this discussion about whether or not a person should be extradited for despite the fact that there's an admission of a political offence. Now, all the judge's questions have been directed at the defence, who are in fact setting out the standard position, the traditional view. The Crown, which is going against that traditional view, is being allowed to say what it wants to say without challenge. Now, that is extremely strange. It ought to be, realistically, the other way round. It ought to be the Crown who is getting the big questions from the judge. Now, what is going to happen within these 3 weeks? It's very difficult for me to say. It seems to me that 2 points are going to be made. Firstly, I think they're going to be working further on, the defence is going to be working further on trying to get more authorities on the point about political offences. The second thing I think they're going to try and do is that they're going to try and show that any trial that Julian Assange will have in the United States will not be fair, and that he faces a very harsh and disproportionate and, if you like, cruel and unusual punishment if he's sent to the United States. And they will also, I think, be trying to argue that it is a case that goes against freedom of the media, freedom of expression. They'll be trying to develop all of those arguments over the last 3 weeks. So we will see how the Crown responds to all of that, but the fact that the Crown has admitted that this is in effect a political trial is already actually a big admission. It's a more important admission than I think people realise, and I think that it's already in a way been a major win, if you like, for the defence. I think also that I'm afraid this judge has shown quite clearly that she's very hostile to Julian Assange, so I don't have optimistic feelings about this hearing. But it does seem to me that we now have multiple very strong appeal points. One on the layout of the court and the way in which he's been kept in this glass box, contrary to his rights. Secondly, this whole business of political, the fact that it's a political offence and whether he should be extradited for a political offence at all. So I think that the defence will now be working increasingly because they've seen the judge, they've heard what she's like, they realise what she's all about. They're going to be working to prepare a very strong appeal to the High Court, which will be the next stage in this case, once we've been through whatever is going to be argued in May. So it's going to be a long, hard battle, but actually I think some important points have been won.
Right.
Yeah.
Yeah. This case could take a very long time. It
Well,
may take years.
I've heard people sort of talk about 2 to 3 years. Now the thing to say about that is that Julian Assange is not in good health. He's been held in Belmarsh prison. There's been this letter from doctors who are concerned about how ill he is. 2 3 years in those kind of conditions. That's very, very grim. And I would hope that the High Court could intervene to do something about that too. The judges refused to intervene to help Julian Assange in terms of the conditions of his imprisonment, his confinement, despite again the Crown saying in the hearing that actually it's quite common for the court to intervene. And again the judge is being more harsh towards Julian Assange than the Crown is.
And I do want to ask you about that as well, because it seems that there would be perhaps some repercussions on the UK if they were to not allow this extradition or not grant this extradition. Is that a fair assessment?
I'm sure that's true. I'm sure that the United States, or maybe I shouldn't talk about the United States, the people who are in power in the United States, I think they would be extremely angry. And I can imagine Mike Pompeo and even Donald Trump and all those people, but certainly Mike Pompeo, Gina Haspel and all the rest on the phone to London, demanding to know what's all this about. And I think they would be extremely angry. And I can imagine people from Washington telling their partners in London, if you want a trade deal with the United States post-Brexit, well, now you've lost it. So I can imagine there will be those sort of pressures. There are also countervailing pressures. I know that there is a great deal of shock and dismay across Europe at the way in which Britain has been acting in this case. There's a letter which I know various jurists are signing, in which they're protesting the treatment of Julian Assange, and I think that the people who work in the High Court, where I used to work in the Royal Courts of Justice, are actually very concerned about that. So obviously there's pressures from the US, there's also pressures from other countries, from people around other countries, and there's also the judges and the lawyers who work in the legal system in Britain who are very worried about the effect this is having on the reputation of the British legal system. So, we have to balance all of these things out, and the British government, like all governments, doesn't speak with a single voice.
Exactly. All right, Alex Mercouris, thank you.